So this is a bit more about software in the business than software in specifics. Particularly, this is more of an advocacy presentation than anything, and that is an issue that I think everyone in this room should be extremely concerned about, and that's software patents. And I can tell you that 2009 was a really rough year for me. Not only was the economy rough, but I got trolled in 2009 and lost about a half a year's worth of effort, lawyers' fees, and a lot of other stuff that went down the drain and momentum in my business. And I want to just talk a little bit about what's broken about this system. Some disclosure, I'm not a lawyer, I'm a software developer. I've been a victim of a patent troll, like I say, 6 months down the drain with my business that we had to basically flush a product and start over because of the cost of the legal process that's involved. And it really becomes, when you become cognizant about what the issue is with software patents, it can really be a distraction from what we as software developers should be doing, which is developing our businesses, developing our software, and creating economic opportunity. I'm actually not going to be going into any patents in this one to show you don't have to worry about that, but if anyone's in the international shipping tracking business, you might want to leave the room. And that's dead serious. If you are, it's time, you can get out. Okay, no one good. This is taken from the United States Constitution. This is the patent clause, and it is the key part of it is the first sentence, to promote the progress of science and the useful arts. And I would argue that software patents today are not doing that anymore, and that if anything, they're actually hindering progress in the useful arts of both the arts and sciences. So a little bit about how patents have And a little bit about how patents have changed over time. When the patent system was designed, it was pretty much physical things, tools, machines, and they were very concrete things, and you used to have to cart your item into the patent office and actually show it functioning to the patent examiner so that you could get your patent. Well, today, you don't have to have a working implementation. If you've read any software patents and you're a software developer, you probably look and go, this would never work. They cover abstract ideas, methods, algorithms. We're not supposed to be patenting these things, but the patent office is rubber stamping stuff that you would not believe. And the claims, and this is the main thing that pertains to software developers. We understand orthogonality in software, and I'm going to cover a little bit about how orthogonality has gotten into the patent process. And it is what is really killing us when it comes to software patents. So if you've ever looked into a patent, it's basically broken up into 4 parts. You have your overview, your abstract, the description of the invention, which is what most people actually look at and say, oh wow, this is the invention. It's all the diagrams, it's the examples, it's the workflows, it's pictures of what the thing should actually look like, or it might have flow charts of what the software is supposed to do or what the components are in the software. And what's really interesting about patents is you can just rip that out and it doesn't matter the way they're writing them today. The most important part are the claims. Patent requirements. These things must be innovative, they must be non-obvious, they must advance the progress of science and the useful arts. That's what the law says, but in practical application, that is not what's happening today. So, we started with machines, we went to methods, and now software and algorithms. Orthogonality. In mathematics, orthogonality is when you have 2 lines that are at a 90-degree angle so that you can move one without affecting the other. We think of it in software is that we want to program to interfaces, we want to have single responsibilities, we want to be able to take out one component and put another in as long as it has the contract of the interface, that everything else that depends on it shouldn't matter. Well, orthogonality in patents is what's killing us today. Because what patent writers are doing today is they're making the description of the invention orthogonal to the claims, such that the claims cover a broad, many inventions, many descriptions of the invention, because they really aren't attached to the description anymore. And I can tell you that the patent troll that trolled me filed their original patent in 1984. Their most recent filing that they did in 2006 has an only slightly edited version of the same description of the invention with a completely different set of claims. And what's interesting is that the claims have evolved over time to where the first claim took up about half a page, to where the first claim that covers way more than that claim did takes up about 5 lines. Because what they're doing is the language has gone from, oh, well, we're going to do this, 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 and this. We claim this specific thing, this specific implementation, and this is how it works, to the most recent one is a method of trapping any moving object and sending an alert through an electronic means. That's the patent. And all you have to do is violate one claim on a patent to be liable. So if you track anything that's in motion and send someone an SMS, an email, you put it on a web page, you put it on a report. These guys claim that even if you hand enter the data and then generate a report or email based upon that, that it violates their patent. That's how broad it is. So, orthogonality in patents has an absolutely chilling effect upon the work that you are doing today. And if you think you can hide under a rock, don't run Google AdWords for your product. That's how the troll found us. So, the claims no longer cover the implementations. They're expressed as abstract ideas, or what they're actually doing today is no longer patenting what the invention is, but what the goal of the invention is. So my patent covers the idea of tracking a shipment. Not how it tracks it, but tracking a shipment. Now you look here, I see the incredulous looks out here, and you think, well, how could this happen? The problem is the patent office is so overburdened that they're rubber stamping this stuff. See, about 3 years ago, someone was granted the patent on a method of rocking a swing from side to side by applying a pressure alternately to the chains on the slide.
Yeah, and there's a patent on the color purple too.
Yes, but the problem is once a patent has been issued, it is deemed valid by the courts, and fighting them costs a lot of money. The patent system as it has evolved in the past primarily consisted of people who were patent holders themselves and were actually producing products based upon those patents. And if you've seen in the past, you've seen many of the bigger software vendors, they cross-license their patents because it's called mutual assured destruction. They don't have any stake in suing the other guy because the other guy probably has patents that covers the stuff that they do. So they don't have a stake in really suing each other. The problem is that non-practicing entities, aka patent trolls, don't produce any products. So no one can come at them and say that they are violating a patent because they don't produce anything. All they produce are patents. So they have no stake in a well-functioning intellectual property business or business environment. All they care about is extracting as much money as they can from people who actually implement the ideas that they come up with. They wait for others to implement them, and then they sue. Our product was a multi-carrier tracking system that we scrape data off of international shippers. If you've ever seen a container on a truck, on a train, on a ship, those are what we tracked. Every single different shipper does it differently. They present the information differently. We thought, well, here's a great way we can make it all consistent. One interface makes sense. The patent that we got sued under was for tracking school buses. But they've made it so general over time. My lawyers, when it eventually came down to it, said unless you have about 7 figures worth of money, that's what it's going to cost to fight it. The typical cost of defending a patent suit is about $1.5 million. Because of the way the patent system works and the litigation practices and the case law that exists today, it's civil law, it's not criminal. Basically, you're guilty until you prove yourself innocent. And once you get into the discovery process, the patent troll is going to basically look at every piece of intellectual property inside your company so they can try and figure out anything that might possibly violate their patents. And when you can patent the goal and not the implementation, it's pretty easy to violate them. Yes? 2 minutes, great. So, typical defense runs about $1.5 million. The actual process of going through and overturning a patent and getting it declared invalid costs about $10 million in a typical case to do that. Unless you have deep pockets withstanding an infringement claim, is almost impossible. So if you're going to start a startup, you have to be careful about what you're doing. And I honestly recommend that you don't go and look at the Google patent search unless you want to be kind of frightened about what's out there. So what can we do today? There are a couple cases before the court that are going on right now. We have In re Bilski, which was oral arguments were heard about, I think it was about 9 months ago. They're going back and forth between the justices to come up with that. And honestly, if that case is upheld, the software patents will be set back a long way because they have to be tied to a specific machine, and that the Ninth Circuit has said that a machine cannot consist of a generic CPU and processor, memory, etc. It has to be specifically designed for a particular transformation. So that would be a really good step forward. But there's also a movement on amongst people to actually go back into the case law going back into the 1800s. And there's two interesting cases, Atlantic Works versus Brady and Railway Company versus Sales, both back in the 1878 and 1882, that deal with braking on railway cars. And you think, what does that have to do with software patents today? And interestingly, it has to do with a whole lot of it, because the whole idea of patenting the goal started back in the innovative period in the railroad period. Remember, railroads used to be high technology, very advanced stuff. And some of this stuff is being brought up. The GNU project has information on software patents, and there's also the, oh jeepers, the name is slipping my mind, but there's endsoftwarepatentsnow.org, I think is the domain name. And honestly, if you're thinking about starting a company and you're in the software business, you need to care about this. And I didn't care much until I got trolled. It was very expensive, and it basically killed a product that I thought had a whole lot of potential. And it's very distracting, and we don't need them to advance the art and science of software development. Thank you.